Hello once again and welcome to the Employment Law Show. I am John Scholes. He is Lior Samfiru. I simply steer the ship, but he's got all the knowledge, so make no mistake on that one. Listen, if you want to reach out anytime, either during or after the show, 1-855-821-5900, help@employmentlawyer.ca. There's also a wonderful website that's fairly new and really robust called pocketemploymentlawyer.ca. We'll drill down into that a little later on in the show. Also coming up this half hour, my friends, social media and the workplace. That is a topic you wouldn't have covered about 15 years ago, but it's big now, so we'll get to that. But we always start with the week that was. What do you got going on?
Hey, John, great. Social media, there's always different things that we touch on in employment law. The employment law evolves, and the law has to evolve with the changing of time. So it's always good to stay up to date on your rights because, you know, maybe the rights that you have now would be different than in the past. Things have changed. And of course, so many people don't understand what those rights are. So we do this show to inform you and educate you and empower you, give you the power of knowing, hey, I know what my rights are. I know what my employer can do to me and what they cannot do to me. That's what the show is all about. So take advantage of us being here. And if you want to talk to me privately, if you're not sure if what I say applies to you, not a problem. I speak to people all the time when I'm not on the air. Go to our website. We'll give you that information, my number, my email address. Easy to contact me. About a week there was. Let me tell you about a scenario that came across my desk over the past few days. I spoke with a lady who was actually calling on behalf of her husband. And she was telling me about his situation. He was let go. He was paid no severance. And, I've been trying to get him to call you. I've been trying to get him to call you, and he won't. So I decided to call for you. And I said, well, why won't he call me? I don't think I sound like such a bad, nasty guy. I said, well, he knows that he's screwed up with the company. Yeah, there was a big project that he was responsible for. It didn't go as well. The company was very disappointed with how it went. So he felt so bad they let him go because of it that he said, well, I screwed up. What's Lior going to do for me? So I'm not going to call him. But she decided to call for him, and I am so glad that she did. Now, listen, he was a long service employee, over 15 years with the same company. And yes, he had screwed up. He made a mistake. We're all human. He made a mistake. But that's not the question. The question is not whether or not he had made a mistake. The question is whether that mistake was bad enough to eliminate those 15 years of service, and did it rise to the level of cause? And the answer was not even close to being cause. Okay, he made a mistake, but one incident, one mistake, almost never going to be cause. By the way, even a number of incidents is probably not going to be cause. It's that difficult to establish cause. So even though he made a mistake, he was wrongfully dismissed. And after 15 years on the job, he probably is looking at 16 to 18 months of pay. 16 to 18 months, that's a lot of money. So yes, I did eventually get her to convince him to call me, and I spoke to him, and now I'm working on helping him get that compensation. But I wanted to remind everyone, just because you may have done something wrong, if you lost your job because of it, that does not mean it's just cause. It does not mean that the company can let you go without compensation. For the company to legally be able to let you go without compensation, you would have had to do something terrible, and usually do it multiple times before the company can actually pull the trigger on that. That is rare. Most people that call me, even though they've done something wrong, that is not a cause termination. That is a wrongful dismissal. If you're ever in that situation, do what this person did for her husband. Give me a call.
So that as an employer, they should have just taken steps to build up a case, and then maybe eventually, possibly, maybe, sort of, they could have let him go.
Yeah, they could have said, here's what went wrong here. We're disappointed. We expect you next time to shape up and be more careful and more diligent. And then maybe if things happen again, at that point, they may be able to pull the trigger on a termination for cause, not to kind of capitalize on one mistake. It doesn't work that way. That's clearly a wrongful dismissal.
Online is employmentlawyer.ca. That is where you go to catch past episodes of this and our radio show as well. You can find a station to tune in, and we take a ton of phone calls over the course of, 7 or 8 years we've been doing radio. And we'll take the phone calls, play them back on here, and we talk about them. Phone call number one's right now.
My brother worked for a large international insurer. For 11 years, he made about $125,000 per year. He had a very, very bad fall, was hospitalized. He first went on short-term then LTD until last week, which would have been 2 years, and they're no longer continuing his benefits or his income replacements. My brother's still not able to return to work of any kind.
How old is your brother?
59.
Everything is okay with his employer at this point?
No, not at all. They are saying there's no job for him there, or is he entitled to severance, or is he entitled to be put to pasture, so to speak? We're just really confused as to next steps.
Another case where the employer is confused with the 2-year cutoff with LTD, huh?
Well, there's two issues here.
Yep.
Number one is being cut off disability. and number two is his employment status. So let's talk about the first one. He's being cut off. And this happens often. You know this. You do the other show dealing with disability issues here, and that is, oftentimes an insurance company is going to say, well, it's been 2 years, we're going to cut you off. We think that you should be able to go find another job. That doesn't matter. If you're still unable to work, if your doctor supports you, your insurance company should not be cutting you off. Therefore, we get often involved to either get the insurance company to change their mind or to negotiate compensation. So that right off the bat is inappropriate. If he's not ready to come back to work, if he's unable to work, if his doctor supports him, the insurance company is wrong here. And that happens all the time. If that ever happens to you, you want to give me a call. But the second issue is, putting aside what's going on with the insurance company, can in fact his insurance company, his employer say, well, wait a second, we're not going to bring you back to work. We don't have a job for you. How does that work with respect to him? So he has a right to his job. They can't treat him as being quit. They can't change anything. They have to follow what his doctor says, okay? If they let him go in this situation, they owe him compensation. It potentially is a human rights violation if they're not trying to bring him back to work. There's so many different things here. And of course, no matter what, if he loses his job as a result of this situation, he is owed severance. So let's take his information. Let's plug that into pocketemploymentlawyer.ca and see how much severance he's actually owed. So if we see on the screen there, you see he's an insurance underwriter, been there for 11 years, 59 years old, making good income. And severance pay calculator, it's part of pocketemploymentlawyer.ca, correctly assesses him as being owed about 14 months pay. Wow. 14 months pay. That's what he's owed. That's why it's so important to get that advice or go to pocketemploymentlawyer.ca.
And we're talking $125,000 salary times 14 months. That's a mitt full coin right there.
That's a lot of money. That's a lot of money that he's legally owed.
Pocketemploymentlawyer.ca, that's the third time we've mentioned it. If you say, what is this? I've never heard of that before, you can go there, pocketemploymentlawyer.ca, and it covers all angles of your employment law, right?
Well, I'm such a big believer in people having access to legal information, to legal advice, that I wanted to give everyone their own employment lawyer. So I created pocketemploymentlawyer.ca. So now you have an employment lawyer with you. If you have a smartphone, a desktop, a tablet, what have you, you have your own employment lawyer with you. You simply go to pocketemploymentlawyer.ca and you can get information and assessment of your legal situation in various matters. We talked about severance. If you lose your job, you're looking at a severance offer, you want to know if that offer is good or not. Spoiler alert, it's not good. But go to pocketemploymentlawyer.ca and check for yourself. The very first place you go to as soon as you step out of that meeting with your severance letter in hand. But maybe you want to know if you've been constructively dismissed. Did the company implement a change that's legal? Maybe you know, just like the first topic I talked about, whether there's just cause to let you go. You go to pocketemploymentlawyer.ca, answer a few questions, find that out. Maybe you want to know if you're an independent contractor or an employee. You probably are an employee if you're wondering. But again, pocketemploymentlawyer.ca to find out, does that and more. So you already have an employment lawyer with you. Now it's up to you to use it. Free, anonymous, easy to use, takes seconds. pocketemploymentlawyer.ca.
Well, you know what? I want to take it for a spin in real time, so I'm going to read this email, and we use Pocket Employment Lawyer to answer the question. It goes as follows. It says, when I started with the company 3 years ago, I had negotiated a work week that included 3 days in the downtown office and 2 days working from home. I've just learned that my employer is planning on ending that agreement cold. Do I have to accept this change?
So here's the interesting thing. His employer did not have to give him that flexibility to begin with, the ability to work from home. But once they do, they can't just take it away. So if your employer gives you something you're not owed, in this case, they give him the ability to work from home, or they give him flexible hours, what have you. Once they've implemented that, that becomes the terms of your employment, which means your employer cannot just change that. They cannot say, oh, we want to go back to the way things used to be. That's often and almost always going to be a constructive dismissal. But we're talking about the pocketemploymentlawyer.ca website. So let's see how this scenario translates into pocketemploymentlawyer.ca. So we see on the screen there, he's been there for 3 years. What the company did is they changed his work location. In other words, instead of working from home, he's going to work in the office. Did it increase his commute? It did, and we can see there the result on the screen that this change in work location will significantly impact your commute. Therefore, it is likely a constructive dismissal. So we see that right there in pocketemploymentlawyer.ca. It's a constructive dismissal. It's not something the company is allowed to do, and you can proceed to calculate your severance from there. easy to use. Check it out yourself.
I'm smiling because it's so cool that you can do that. Otherwise, someone would be faced with this. They wouldn't know where to go. Like, how do you even formulate that into words as to solve the problem?
That's
and
it.
They're 3/4 of the way there. Right?
Isn't technology great, right?
It's pretty cool.
It is that. So you have your lawyer with you already. You have it. You have your own lawyer with you all the time. So stand up for your rights. Check out pocketemploymentlawyer.ca.
Phone call 1-855-821-5900 and employmentlawyer.ca online as well. We'll take a short break and get into social media in the workplace. That is on the way. Stick around. This is the Employment Law Show.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Employment Law Show. John Scholes, Lior, Samfiru. This is the part of the show we take a bunch of talking points and a topic and we drill down and give you more and more information. This one's, I'd say, not super recent, but in the last 10 or 15 years, this has become really to the forefront. That is social media and the workplace. So we'll get to these. Are things you post on social media private? Is there such a thing as a right to privacy on social media in the workplace? At home's different, but...
It is different. So let's start with the idea that you should always assume that whatever you do on a work computer can be viewed by your employer. Your employer does have, from a technological standpoint, the ability to monitor what you do, and some employers do that. They may not tell you, but they may be able to monitor and see whatever it is you do on your work computer. So therefore, if you're on social media in the workplace, that's a problem, because some employers may think, well, why are you spending too much time on that? Or they may be able to see what you're posting. And if you don't want that to happen, don't use your work computer. When it comes to the workplace, generally speaking, if you're using a work computer, there cannot be an expectation for privacy. Now, if you're at home using your own phone or your own laptop, yes, obviously there has to be an expectation of privacy, or our whole legal system collapses. But when it comes to work, no, there really isn't or can't be. Same thing if you're using a work phone and you're posting things or saying things. Always assume that someone can see it. Always assume that it can come out. And if you don't want your employer to see what you're posting, if you don't want your employer to know that you're spending time on social media, don't do it. Certainly not on a work computer.
Number two is this: what happens if an employee bullies or harasses another employee through social media channels?
It happens. When I started practicing law, if someone was going to bully or harass you, they'd probably do it to your face. Now, social media, we hear a lot about bullying and harassing. We've read stories online and we've read news items, people getting bullied through social media. Well, let's start with the idea that bullying in the workplace is a real problem. Harassment is a problem, and an employer has an obligation to protect employees from being harassed and mistreated. That applies to social media. If an employee is being bullied or harassed by others through social media postings, that is still something that the company has to deal with. Even though the postings may happen off hours, it still translates to the workplace, so that's inappropriate. So if you're being harassed and bullied on social media, you can and you should and you must tell your employer about that. Make sure that they're aware and give them the opportunity to do something about it. Because if they don't, that could be potentially a human rights violation. That could certainly be a constructive dismissal. So it's inappropriate to be the victim of bullying, period, regardless of whether it happens, face-to-face or online. And if you're in that situation, first thing you do, if possible, give the company the opportunity to fix the problem.
If I'm an employer and I've got an employee who I think is spending way too much time on social media, I want to curtail it, I want to discipline them. How do I go about doing that?
So certainly an employer can expect that that if you're at work, you're doing work. You're not spending too much time doing other things. Now, it's not going to be reasonable to say, well, you can't do anything. You can't even go and check an email or go on Facebook one time. It's not a sweatshop, and that would be unreasonable. But certainly, excessive use of social media, and we all know people who may spend a bit too much time on that, is not appropriate in the workplace. And if an employer does get the notion, the idea that the employee is spending too much time for which they're being paid, they're spending too much time on social media, they can and they should discipline. So what does an employer do? I would first make sure that you have policies in place, talking about what's expected and what social media is allowed and what's not allowed. Have those policies in place, make sure employees know about it. Give them a copy, explain that to them, have them sign something that says we understand what it all means. If the employee still breaches the policy, you have to discipline. You may start off with a warning and then maybe escalate to a second warning, perhaps then even a suspension. And then and only then could you consider perhaps a termination for cause. If you've tried to discipline, if you've tried to correct the behavior and the employee hasn't gotten it, maybe then you can consider a constructive dismissal or consider a termination for cause, But it starts with having a good social media use policy.
We're talking about navigating social media in the workplace for the topic of this conversation. Can you get in trouble if you say bad things about your boss on your personal social media accounts?
You absolutely can. And, you may say, well, this is a kind of a private account. I only have some friends that are friends with me on this account, so my boss will not know about it. That's not the issue. Yeah, you're right. If your boss never finds out about it, I guess it's fine. But if you say some things about your company that are negative or about your boss and they find out about it, either they somehow see it or someone tells them, that is a problem. Even if it's a private thing, even if it's not accessible to the public, it's still going to be something you can be disciplined for. It still could be something that the company is not going to be happy about. So I say, don't take that risk unless you really don't care about your job or really don't care about potentially being disciplined, maybe even terminated in some situations. Don't do that. There's no such thing as completely private. There's no such thing as no one will ever see this. We've all read stories how things that were supposed to be private blew up. So don't take that risk.
Delete button doesn't really exist in social media.
It never goes away.
Exactly.
If people know what they're doing, they can always recover things. And that's the thing about the internet, certainly social media. It never actually goes away.
Last one is this. I've been fired from my job for using social media. What do I do now?
So here's the thing. Just because you've been using it, and even if you've been using it, more than you should have, I've spent too much time on it, maybe I should have not done that. Remember what I said before, that does not mean that that's cause for termination because it's so difficult to terminate for cause. It's reserved for the worst offenders. So the fact that you may have done something wrong, the fact that you've spent too much time, it does not mean that that's cause. It does not mean that you're deserving of the worst penalty. So what do? Well, you have to reach out to me and we can talk about that and get you the severance that you're owed. But always a good advice, if you're working, if you're getting paid to work, obviously spend time working. If the company allows some social media use, that's great. Make sure you understand what the policies are, make sure you understand what the expectations are, and stay on the right side of those expectations. But if you are let go, despite what I said, chances are it's still a wrongful dismissal. You want to give me a call.
Call indeed, 1-855-821-5900, help at employmentlawyer.ca, or simply employmentlawyer.ca is the website to catch our past TV shows and the radio show as well. Phone call number 2 for the day is coming up now.
Let's say you're a contract worker and you're responsible for your own T4 and your own income tax and you're basically self-employed, but you depend on this one company for work and then all of a sudden they terminate you or they cut your contract and you don't make as much money with them. Are you entitled to any severance at all? I have to be there at a certain time and I have to meet time commitments all the time and I don't use my own tools.
Yeah.
You're an employee.
That's it. You ruined it. I'm off.
Done.
That's it.
Have a good day.
No, but that is a classic misclassification situation. Classic. Where, you work for one company. They tell you where to go. They tell you what to do. They give you the tools to do the job. But no, you're really an independent contractor. Nonsense. Of course not. When you call a plumber to your house, they'll tell you when they'll come in.
That's right.
And they'll bring their own tools and materials. And then they're not going to be doing this every day for you from 9 to 5 because the plumber that you call to your house is an independent contractor. They're not really your employee just because they came to fix a plumbing problem. Well, that's very different than this situation. It's very different than the situation our viewers are going to face when they're on paper independent contractors. Maybe they'll be filing their taxes as independent contractors, but they're really employees because they work for one company or mostly for one company, because they take direction from a company, because they look like an employee.
Right.
If you look like an employee and act like an employee, then you are an employee regardless of what you may have signed. And that means if you lost that job, you're going to be owed severance like an employee. But we've been talking about pocketemploymentlawyer.ca. So let's actually see how on pocketemploymentlawyer.ca, this particular person that called us on our radio show, how she could have found out if she was an employee or contractor. So let's plug her information in there. Does she work exclusively for one company? The answer is yes, so she would have picked yes. Does she set her own hours? She told us she does not, so she would have said no. Does she pay for the expenses? No, she does not. And has she been working for the same company for more than 6 months? She has. Well, we can see the result on pocketemploymentlawyer.ca. Yes, it is very likely that you're actually an employee and not an independent contractor. You provided that assessment right there.
Yeah.
It's that easy to use. You check it out for yourself. Maybe you've been working for the same company for a while, and kind of in the back of your mind, you've always wondered, am I really an employee, or maybe I'm really an independent contractor? What am I? Go to pocketemploymentlawyer.ca and remember that, especially if you lose that job. Because if you truly are an independent contractor, you're not going to get severance. But if you really are an employee because you've been misclassified, you're going to get all the severance that an employee gets. So check it out for yourself.
Unjust dismissals, what are they? We'll unpack that after a short break. 1-855-821-5900 and employmentlawyer.ca. This is the Employment Law Show. We'll be right back. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. You want to reach out, employmentlawyer.ca is the website. Put a help at in front of it. And pardon me, you'll get an email address from that website. You can find our radio show where we pull all our phone calls from and talk about them. Phone call number 3 is right now.
Of ours is 60 years old, worked 32 years at the same company. It's a large company, making $45,000 a year. And I'm not sure if it's run out, but she was given 8 months severance.
32, that's literally a generation. 32 years is a generation. That's a long time to be in a workplace.
Time. But, you know, I bet you if she asked many people, said 32 years, she was given 8 months, yeah, it's like, let's say 34 weeks. Hey, that's more than a week per year. So that's for an extra couple of weeks. Take it. That's great news.
You know.
Not even close, John. Oh, my gosh, after 32 years, she's owed 24 months pay. It's as simple as that. So forget about 8 months. She's owed, what, 3 times what she was offered. 3 times. And I don't know how much this person's earning, but obviously it's going to be a heck of a lot of money, a big difference between 8 months and 24 months. And just one more time, let's run it in pocketemploymentlawyer.ca to see how this person could have found out, just as easily as I've said it now, how much she's actually owed. So we can see on the screen there for 32 years in a clerical role. At the age of 60, he was given 8 months pay, and we can see right around 24 months, 18 to 24 months pay is what she's owed. At her compensation level, that's somewhere between $37,000 and $60,000 difference. That's how easy it is to find out what you're owed.
Crazy.
So that's why it works that, so quickly. Just as quickly as I read it, you can do it yourself. pocketemploymentlawyer.ca.
There is yet another resource for you, though, terminationquestions.com. You can go there, ask your questions. They get answered by Lior, a member of his team. This one from Valerie. Pardon me. Valerie says, what is an unjust dismissal? I worked in a federally regulated industry and have heard this term tossed around by my coworkers.
So it's interesting. So most people in this province are provincially regulated.
Okay.
So for a provincially regulated employee, if you've been let go and you haven't received the severance that you owed, or the company made allegations against you that are false, that's a wrongful dismissal. We use it a bit of a different term for federally regulated employees. So who's federally regulated? You have bank workers, you have rail workers, you have people that work in telecommunications, radio, TV, etc. They're federally regulated. So for a federally regulated, the term usually is unjust dismissal. That can mean one of two things. Okay, either you've been let go and you haven't received proper compensation, but in some situations, a federally regulated employer is not allowed at all to let someone go. Generally speaking, federally regulated employers cannot just let someone go just because, which means you may actually have a right to your job back.
Wow.
So that doesn't apply to provincially regulated employees. Provincially regulated employees, it's just a matter of compensation and severance. Generally, you cannot get your job back. But for a federally regulated employee that's been unjustly dismissed, they may be able to get their job back, get this done with back pay. So it's a significant right that you have. Our courts have opened the door to this process over the past couple of years.
Wow.
So if you're a federally regulated employee, remember, first of all, severance rules apply to you. Same severance rules. You can go to pocketemploymentlawyer.ca, but you may have an additional remedy. Doesn't apply to everyone. It certainly doesn't apply to managers, but people that are not managers may have a right to get their job back with back pay. It's an unjust dismissal. Again, another reason to get some advice if you've been let go.
Again, terminationquestions.com. We'll get to one more here. We got time. Victor writes in and says, Lior, what makes a severance package fair? How do I know if I've been offered a fair severance package or not?
And usually when I get a question like that, it is also accompanied by another comment that says, well, because I contacted the Ministry of Labor, or I went on the Ministry of Labor website and they told me it's a week per year, and you're saying it's more than that, so what gives? So a fair severance package is one that complies with the law. It's as simple as that. And our laws made it clear that unless you sign an employment agreement that limits your entitlements, you're owed severance based on your age, your position, and the length of your employment, and a couple of other factors. And for some people, that could mean 3 months severance. For some people, it could mean 24 months severance, and pretty much anywhere in between. So a fair severance package is not just about the number of months pay that you get. It's also about what's included in it. So if you've been let go, let's say you're owed 12 months severance. Well, that means you also have to get not just your salary, but your bonus, your benefits, your car allowance, your stock options, your pension contributions. All that has to be included as part of your severance. And if let's say the company said, we'll give you 12 months of salary, but just salary, we're not going to include your benefits and your bonus, that's still not fair. That's still a wrongful dismissal, okay? So it's your job, if you're the employee staring at that severance letter, to determine that the company's complied with its legal obligations. In 90% of the cases, 90%, the severance that the person is offered is a heck of a lot less than what they're actually owed. Either less number of months or not all components of compensation are included. So you call me, you call another lawyer if you really think Lior doesn't know what he's talking about, fine. Or you go to pocketemploymentlawyer.ca. That's how you find out if you got a fair severance package. The first thing you do, you just grab your smartphone, pocketemploymentlawyer.ca, tells you 10 seconds flat in that period of time what you're owed, and now you know.
In two seconds, what if you're in sales? You're on commission.
Commission has to be included, John.
Right.
So if you're on average make $5,000 a month in commission, that has to be included over the severance period.
Gotcha. It's
not just your salary. So important to get that advice. Some people, salespeople, may get a lot of commissions. They may have little or no base salary.
Right.
But we still look at their total earnings to calculate their severance.
We're done. You know how to reach out. 1-855-821-5900. Pocketemploymentlawyer.ca. Always write that down. Keep it. You'll need it one day. You'll want to know the information. Email what we pull from is help@employmentlawyer.ca. There's also that, terminationquestions.com, and quite simply, employmentlawyer.ca is the website. There you can catch past TV shows, links to our radio show as well. Thank you so much once again for joining us. Employment Law Show. We'll catch you again next time.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.